A trust by itself won't avoid probate. The reason why this is because it comes down to how a trust actually works and how assets are held in trust. Hi there, my name is William Ha. I'm a California licensed estate planning attorney. I do wills and trusts, and I help people avoid the probate process here in the state. I've been a licensed attorney since 2008, and some disclaimers here. Number one, everything in this video is for legal information only, and you should not be relying on it as legal advice. Number two, no attorney-client relationship is formed by watching this video. The vast majority of my clients hire me because they wish to avoid the probate process when they pass away. This is really great and very common motivation because probate is number one, slow, number two, expensive, and lastly, it's public. Having a trust-based estate plan in place can set people up to avoid the probate process when the trust is properly used. On the other hand, a will itself won't avoid probate because it's a document that merely overrides the default rules that will apply in probate. So let me take a step back. The general rule is that if you die with assets in your personal name and there are no beneficiary designations with the institutions that hold those accounts, so checking accounts, investment accounts, or in the case of a house, how you hold the title in the deed, when you pass away, those assets will have to go through probate to get it sorted out. You can think of probate as a lost and found for your assets. The difference is that creditors can file claims, ask and get paid, and what's left over is either distributed to your named beneficiaries from your will, if you have one, or to your heirs if you don't. And if no one comes forward in the probate, then the assets will go to the state. When you have a will, you'll still be in the probate process and creditors will still file proofs of claims, but with a will, you can, number one, appoint who you would like to act as your executor. This person will be responsible for the tasks of ensuring that creditors are paid and beneficiaries and heirs are given what's left. Number two, list how you want those assets to be distributed to your beneficiaries. Number three, nominate potential guardians for your minor children. And number four, decide whether bond will be required to serve as an executor. These are some of the main functions of having a will. On the other hand, when you die without assets in your personal name, no probate is necessary. There are no assets to probate. Now let's talk about a trust. The reason why a trust works to avoid probate is because when you have a trust and you hold assets in trust, it's actually no longer held in your personal name. Instead, the asset is held by a trustee of a trust. So what's a trustee? When there's a trust, there are three parties involved: the trustor, the trustee, and the beneficiary. The three parties represent a relationship that includes duties and rights. Because of this, it's more accurate to think of a trust as an agreement to a relationship than it is to think of it as an entity like a corporation or an LLC. A trustor is a person who created the trust. A trustee is a person who manages the asset to be held in trust for the benefit of the beneficiary. Generally, when you create a revocable living trust, you occupy all three positions while you're still alive and well. It's not until you pass or when you're unable to manage your own affairs that this will change. What makes this setup work is once the trust turns into an irrevocable trust because of the death of the trustor, the successor trustee who you've nominated has duties to carry out instructions of the trust for the beneficiary. For example, the trust may say, "Give my house to my daughter outright." If the successor trustee does not do this, then they can be sued by the beneficiary. So going back to the reason why having a trust alone doesn't avoid probate is because people fail to transfer the asset, such as the house or checking account, to be held in trust by the trustee. If you don't do this, then it's still legally in your personal name, and when you die, it will generally have to go through the probate process to get it sorted out. So let me give you a visual example to really bring this home. Imagine you're flying on a plane with 3 checked suitcases, just a regular commercial flight. Each of your suitcases represent one of your assets: your house, your bank account, your investment account. You tag 2 of the bags with a really clear label that says, "This belongs to my trust. If I can't pick it up, my successor trustee can in my place." But the third one doesn't have a special tag like that. It's just a tag that has your name No additional labels, no instructions. So let's say you pass away mid-flight. At baggage claim, your successor trustee shows up. They certify that they are the successor trustee, and they're allowed to pick up the 2 bags. No issue. But when they reach for the 3rd one, the airline person stops them and says, sorry, this bag is not part of the trust and it's not your name. You'll need to go to court to prove that you're authorized to claim it. When this person asks you to go to court, in real life, the analog is that it's probate court. And even if it's just one asset left out, that alone can trigger the entire probate process, especially in California where the threshold is just over $184,500 for assets that are held outside of trust. So what's the takeaway here? Creating a trust is only really just half the battle. Funding the trust is the other half. You need to make sure that every asset that you want to be passed on through trust, your house, your accounts, your investments, are all properly titled in the name of the trustee of the trust. Otherwise, your family still might face probate despite all your estate planning efforts. Thank you for watching. Please like and subscribe for more estate planning tips.